Hi everyone, I'm Madelena Viksne from Samfiru, Tumarkin. I'm an employment lawyer, um, and I'm here to answer some questions for everyone today. Um, Before we get started, unless there are some questions right away, um, I just wanted to remind everyone that the Working for Workers Act is in effect right now. Um, and one of the things that means is that any employers who have 25 or more employees as of January 1st have to have a written policy in place by March for all employees to disconnect. Um, that means disconnecting is defined as engaging in work related activities such as email and so on um, after a certain period of time so as to be free from the performance of work. Um, it's somewhat unspecific, the language of the legislation at this point. So it doesn't prohibit work outside of normal hours. There's no consequence for that. And there's no exceptions for executives or higher ranking employees who practically might be expected to be available. So likely it will be further clarified by a regulation at some point. Um, the legislation also um, voids non-competes that were entered into after October 25th, 2020. Um, so not necessarily applicable to those that were entered into prior to that point, but historically our courts have not favored enforcing non-competes unless they're actually required to protect the business interests, are reasonable, and are sufficiently time, geographically, and scope limited. Um, so this could mean ultimately that the courts take a stronger stand moving forward against them, even though they already take quite a strong stand. But that is to be seen in cases that will come moving forward. So Mr. P from YouTube said, I've heard that the hospitals in Ontario are fighting employees terminated due to vaccine mandates. Has there been any court decisions you can share with us? Um, as far as I'm aware, I don't know of any non-unionized court decisions that have come forward. The arbitration and union-based decisions have not been in favor of the employees. They've favored the employer. And essentially what they've said is um, it's not a forced vaccination policy. What is happening is that you are being forced to choose between two things that you don't want to choose between, but that the loss of employment is something that's compensable with money, um, and therefore a repairable harm as opposed to an irreparable harm. So that's sort of the overall um, the couple of decisions that we've seen relating to vaccines in the union context. That's sort of what the summary of their decisions is, very briefly. Um, but that it's still to be seen in terms of non-unionized employees. Question from Tammy on YouTube. I was injured at work. Despite multiple medical notes from my doctor about how to accommodate, my employer refused to do so, resulting in full body injury. What can I do? Well, Tammy, I think the first thing that you need to do is contact our office and speak to someone in our office. Um, in order to really evaluate your case, we would need to see sort of the medical records and correspondence between you and your employer, and understand more sort of specifics about your condition, and what happened and what accommodations were required and so on. But your employer does have an obligation to accommodate you to the point of undue hardship. That's a very high threshold. Um, it's pretty difficult for an employer to reach. It usually has to do with financial costs relating to accommodation. So most employers, it doesn't. There, it is a very high level of proof that you have to reach to prove that you've done everything you can up to that point. Um, so if your employer's is refusing accommodation for you, then you should certainly talk to a lawyer. So I would recommend calling our office. Has any court case of people being terminated for not taking vaccine, has anyone been successful? That's G from Facebook. Um, as I mentioned just a moment ago, the only decisions that I'm aware of at this point are decisions in the context of unionized employees, which is a bit of a different process, where the unions brought a grievance against a vaccine policy. So far, the arbitrators or the board have sided with the union. Yeah, sorry, have sided with the employer against the union and therefore against the employee's grievance. So no, not that I'm aware of at this point. Yeah. My employer has said that my position, sorry, this is Belinda, from YouTube. My employer has said that my position is a contract position and I'm considered a contractor. What does that mean and how do I know if I'm considered a contractor or not? Um, Belinda, I would suggest that potentially you call our office. I'm not really sure in what context this conversation is happening with your employer, where your sort of employment status is being discussed. But um, if you are a contractor, you likely have been invoicing your employer and paying HST on your own. They haven't been taking money off of your paychecks for withholdings like EI or CPP, which could end up with you having some sort of a tax consequence in a tax season. Um, in terms of how you determine whether or not you're a contractor, most employees who are said to be contractors are actually more likely dependent contractors than independent contractors, which means that you have essentially the same rights as an employee under the Employment Standards Act. But in order to make that determination, there's a number of different factors that we would have to walk you through and understand more about the specific facts of your case, such as like, do you have to ask permission to take vacation? Do they supply most of your tools? Do you have a chance of profit or loss? Like, there's quite a few of them. So, the best thing to do would be to call our office and set up a call with one of our, a consult with one of our lawyers in order to determine, sort of go through your analysis more specifically. Um, Sorry, and what it would mean for you if you are an independent contractor is that you would be bound by the terms of your agreement as a contract, not as an employment agreement, and wouldn't be protected by the Employment Standards Act with respect to like things like termination pay, overtime pay, and so on. Um, Liana asked, from Facebook asked, do we need to disclose a vaccination status if not asked and it wasn't part of the employment agreement? Uh, I'm not sure what you mean, because if you are not being asked to disclose your status, I'm not sure why this would be coming up. But if it's not part of your employment agreement, I mean, you never have to disclose your personal health information. But if you refuse to disclose your vaccination status, your employer is very likely to treat you as an unvaccinated employee. I don't know if, in the context of your specific employer, there is a mandate of some kind or a policy of some kind in place where there are some consequences for being unvaccinated. I would advise that if you are vaccinated, it's likely an easier scenario if you just disclose your status. Because if you do not, your employer will be treating you as an unvaccinated employee because they can't make a determination one way or the other. And that means that whatever consequences come from being unvaccinated are likely to apply to you as well. So the dreamer from YouTube said, even though non-competes are prohibited under the ESA, can the employer still try to enforce it if it was signed before 2020? So the Working for Workers Act is not the ESA specifically, and it does stipulate that it applies to non-competes. It voids any non-competes, sorry, that were entered into after October 25th, 2021. As I said earlier, it doesn't necessarily apply to those signed before that. But historically, our courts don't tend to like to enforce them. Um, unless they're actually extremely necessary, like you are in a fiduciary position of some kind. Um, and also, they always have to be sufficiently time geographically and scope limited in terms of what is restricted. So something that's like 5 years for all of North America, in anything mechanical is not going to fly. But something that's, um, in the GTA or within 5 kilometers of the prior business, um, for 6 months after termination, and in the very specific field that you work in, that could maybe be, not guaranteed. It could go either way, but the new legislation could possibly mean that the courts take a stronger stand against them because they don't tend to like to enforce them. My employer so Adam from Facebook said my employer mandates 6 days a week, and I'm separated, so therefore I have my kids every other weekend and have no one to watch them when I have them. They say they will mandate me anyways. Um, so this question is a little bit complicated because it kind of goes into what your hours are each day, whether you're exceeding 44 hours, where in Canada you're located, in terms of what the exact overtime rules and so on might be, and what employment standards legislation applies to you specifically. Um, However, at least in Ontario, and I'm just going to speak for Ontario because I'm not sure where you're from. Um, you're protected under the Ontario Human Rights Code if you have family or caregiver obligations that are requiring accommodation from your employer. So one of the things that I usually recommend somebody do is go and like explore every other option that you might have available to you for daycare or caregiving services for whatever your obligations are, so that you can bring that to your employer at the time that you request the accommodation. Um, and they can sort of see that you've done the work, that these other things aren't available to you, and therefore you require the assistance that you're asking for. It's just helpful usually in terms of the discussion that you're having with them. But regardless of that, you are entitled to protection under the at least Ontario Human Rights Code, for family status, which would include caregiving obligations for your children. So if you request it as an accommodation, your employer has the obligation to accommodate you up to the point of undue hardship, which would entail giving you the extra day off every other week potentially, or some kind of other arrangement that you potentially can work out with them. So Kelly Orchard said, I received working notice for refusing to get vaccinated. I work remote 100% in a different province. I'm wondering, in addition to working notice, am I still entitled to severance? And do I have a case for wrongful dismissal? I've been employed for 14 years and remote for 9 years, 4 of those years in a different province. Uh, well, your question depends on a number of different things. I'm not sure where your employer is based or where you're based at this point. Um, I also would, I'm not, I don't know anything. In order to determine whether you would be entitled to severance under the Employment Standards Act of Ontario, at least, you would, I would need to know what the payroll is or how many employees the employer has, because there is a restriction with respect to that. Um, with regards to whether or not you are entitled to further notice, such as reasonable notice at common law, uh, it would be, I would recommend that you contact our office and speak to someone there to determine whether or not your employment contract is restrictive, or whether or not it has an enforceable termination clause, um, and whether there's more that can be done in terms of entitlements for you, in your particular case. I think that it sounds to me that it might be a case where you would want to speak to somebody more specifically. So Mark from YouTube said, what sort of changes is my employer allowed to make to my pay or bonus structure? We're looking at reduced commission on sales as a result of COVID. So this depends on whether what you're saying is they are reducing like they're changing your bonus of pay policy in terms of commission. So you used to get 15% and now you get 10% or something. Um, or whether what you're saying is that your pay has just been reduced because you're making less sales due to COVID. If it's just the latter, where the business is just suffering, um, your employer can't be responsible for that in terms of it being something that is attributed to their behavior, unless they've actually made a specific change. So if they've come in and implemented a new commission or bonus policy, um, uh, then it could be problematic for them. Absolutely. Part of the evaluation has to do with how much of a change it is from the previous policy that was in place. For instance, like what is the loss that you're going to suffer for the year? Are you going to suffer a 20% or a 3% loss? So that's part of the evaluation in terms of whether it would be enough to establish a constructive termination. Also, whether or not you've sort of signed off on the policy on already, and how long it's been implemented before you um, reject it. If you don't want to agree to it, you don't have an obligation to sign a new contract or term of contract. And if they terminate you for not signing it or say you can't come into work until you do, that is a termination. And so they would be able, so you would be able to potentially um, pursue severance. So I would suggest that you speak to somebody about your specific policy, meaning like that we can review it. Sorry. That you arrange a consult so that we can actually review the policy in place and your contract and understand sort of the specifics in terms of your losses and what the policy actually is going to mean, in the event that it is actually a policy. If what you're talking about is just you've suffered losses due to COVID because your sales have been lower, but it's not actually something that was imposed by the employer, then that's just sort of there's nothing really you can do about that. So Randolph from YouTube said, "How do you deal with a performance improvement plan if you don't agree and did not make mistakes your employer is claiming?" Well, don't sign anything, first of all. If you don't agree to what they're saying in the section that sort of is describing what the performance issues are, you shouldn't sign, at least not until you speak with a lawyer, and have them review it as well. It also, in some ways, depends on whether this is, there have been other gradual steps leading up to this point. So, have you received verbal warnings about the same things? Have you received any written warnings prior to the performance improvement plan? Have they provided you with extra training? What exactly is the performance improvement plan requiring of you? Does it reference discipline up to and including termination in the actual plan that they're asking you to sign? So there's a lot of specifics that you would want to sort of consider in terms of what your next steps would be. So I would again suggest that you contact our office and set up a consultation. Make sure you have a copy of the performance improvement plan. If they're asking you to sign it, then certainly I would say that you want to take a copy of it home and you need some time, so that you can provide that to whoever it is that you speak to, who can sort of give you a specific valuation. So Kelly, if you're, this is sort of going back to Kelly's previous question. If your employer is Ontario based, then ostensibly you would be entitled to severance under the Employment Standards Act if they have 1,000 employees. Um, but it again, whether or not there would be something more above and beyond the Employment Standards Act severance is going to depend on your contract or whether or not there is a contract. So it would be best to contact our office. Okay, so Brendan asked, what is duty to mitigate and how does it take away from any severance awarded in constructive dismissal claims? So the duty to mitigate, it doesn't take away severance. So what it means is when you are terminated, the entire purpose of common law reasonable notice is that your employer is sort of helping you to bridge the gap between your termination and your next employment. It doesn't always bridge the entire gap, but it's sort of meant to help you during that period where you're unexpectedly without a job. Um, in exchange for them continuing to pay you throughout this period where you're sort of supposed to use that time to look for new employment, you have a corresponding obligation to be looking for new employment. And if you get an offer for a comparable reemployment that is, relatively similar, uses the same sort of job skills, and is sort of within 10-ish% of your previous salary, you should accept it. If you don't accept it, it's considered a failure. It may be considered a failure to mitigate by the courts, which can reduce what your ultimate reward is. Um, in terms of the duty to mitigate, if you get a job, so say you have like a 12-month claim. If you get a job at 6 months, but you're making less money at the new job, your previous employer is still obligated to um, make sure you don't suffer any losses during that specific period that applies to you for notice. But they're not required to pay you the full amount because some of the money that you're earning from this new job is reducing your losses. So it's almost like the new money that you're getting is a credit against the losses that you had. So if you're making $10 less an hour than you were at your previous employer would still be obligated to top you up to that $10, but they don't have to pay the full amount because you're already making that at your new employment. So that's, I think, what you mean by takeaway from severance awards. It's just that any earnings that you have during the mitigation period, which would be the notice period that you're awarded, are reduced from the overall award because you've already earned the money. It would sort of be like double dipping. I'm not sure if that makes sense, but it's essentially you can't double dip. So if you're already making up your losses through employment, then your old employer isn't required to continue to pay that amount, but they would still have to ensure that you are not suffering losses during that period, and that includes any compensation-based benefits. So things like health benefits and salary, bonuses, all of that stuff. Oh, bonuses sometimes, but salary, commissions, and benefits for sure. In BC, I believe there is a law that says businesses must allow delivery drivers in washroom access, given that vaccination requirements may be required or requested for entry. Can access be granted? I'm not sure about in BC specifically, but in Ontario, the vaccine passports, I don't believe, are required for access to a washroom, or if you're just passing through to go to like a back patio or something like that. I believe that there is a exception, at least in Ontario, for that. So that may be the same in BC. I'm sorry, I'm not certain on that answer, JC. From Tanya on Facebook, I'm a unionized nurse who was placed on indefinite leave because of the vaccine mandate. I want to sue my employer for emotional distress. Can an employment lawyer help me, or should I go the route of civic court and personally sue people from hospital leadership? As a unionized nurse, your only real option in terms of the employment context is to go through your union itself and file a grievance. If your union isn't helping you, it's still not possible for an employment lawyer to help you because you're restricted by your collective agreement, which requires that you go through the union. If you feel that your union is not representing you properly, you can file a duty of fair representation um, allegation against them with the labor board. but they're not very often successful, and it's not. I personally wouldn't necessarily recommend it, um, but it could be worth a try if you want to do that. Um, I'm not sure that I would recommend that you personally sue individuals within the hospital, because regardless, the hospital would be liable for the hospital is likely vicariously liable for the conduct of its employees regardless. So ultimately, it's going to end up being the hospital, and then you'll be in breach of your collective agreement, possibly, depending on the terms of that. Um, but but the first step is to go through your union. So for JC, he asked, is the disconnect the right to disconnect federal or Ontario only? The Working for Workers Act is an Ontario. It's a piece of Ontario legislation. Um, I believe I can double check right now. Yeah, it's an Ontario. It's an Ontario legislation, so it wouldn't apply to federally necessarily. It doesn't mean that other provinces or even federally that it wouldn't come into place, but at this moment in time, it's not. It's not a federal law. Okay, so it was. Oh, okay. One last question, and then that's it. Can my employer force me to change locations due to workload? They want to change my commute by at least 3 hours daily. Um, a significant change in terms of the terms of your employment is not allowed. It's if the change in terms of your location is significant, and 3 hours a day commute sounds quite significant to me, and is potentially, arguable as a significant change, then I would think that you would have to agree to those being new terms of your employment. Otherwise, it may potentially amount to a constructive dismissal. If that's something that's being imposed on you right now, this change, then I would potentially speak to someone in our office just to make sure that there isn't a term in your contract that allows it, or that there hasn't been some sort of surreptitious agreement to being relocated at different times in your employment. Um, but if those types of terms don't exist that would allow your employer to make the type of a change specifically, then forcing a relocation is could potentially amount to a constructive dismissal. So it would be worth talking to a lawyer. Jay Jord from YouTube asked, "What is the legal statutory amount of time that your employer has to give you your ROE?" I believe that they're supposed to file it within 5 or 7 days. It should be available to you on Service Canada's website. Um, it would depend on whether or not they file it. I think there's one rule for a paper copy and one for if they're filing electronically. So I think they get a bit of more leeway with a paper copy, but it's supposed to be within about a week. If Lisa, if you want to speak to someone in our office, the number is at the bottom of the screen, and you can speak to somebody in our intake department who will get more information from you and set you up with a consultation if that's what's appropriate. So that's it for the questions today. If you need to contact us at any point for assistance, email us at help@employmentlawyers.ca, or visit our website, or you can call our intake department. The number's been up on the screen a number of times now, and we will see you in a couple weeks. Thanks so much.